The Board of License Dietitian meeting is convening at 9:02 a.m. on April 16th, 2025. This meeting is being held in person and through MS Teams video conference and is being recorded. The recording will be posted to the internet for public viewing. I now call the roll. Proctor? Here. Elnett? Here. Kegel?
Here.
Ockel?
Here.
Online. McFarland?
He's not going to join us today.
Dr. P?
Here.
Members, when you wish to speak, please state your last name for the record. Board members are asked not to use the chat feature during the meeting. The Health Licensing Office asks that individuals attending through MS Teams keep their phones muted and cameras off during the entire meeting or until they're given the opportunity to comment during the public and interested parties feedback period, if indicated on the agenda. Public comment is limited to matters listed on the meeting agenda or topics relevant to what this board has statutory authority to regulate. Public members wishing to speak, please sign in on the roster sheet available in the room or email Josh Page at Josh.Page, spelled out Page, at OHA.Oregon.gov and provide your first and last name. Everyone is asked to use appropriate language, manners, and protocols when conducting board business.
Thank you, Chair. Morning, everybody. The first item on the agenda is approval of the agenda. So we need a first and a second. Approve the agenda.
Pavlinak, I move to approve the agenda.
Cindy, second?
I'll second it. Russ Cagle.
Thank you. All in favor? Let's go to vote. Proctor, aye. Elnett? Sorry, aye. Kegel?
Aye.
Otto?
Aye.
Me?
Aye.
Bianca has done a vote.
Thank you. This is Bob Bothwell again. Next item on the agenda is the director's report, which I will give. And the first item on that report is the licensed dietitian board membership. And we have Julia, who's in second term and expired just on the 20th. And Julia cannot reappoint. Jesse Pavlinak is in the first term and it expires 6/29 of 26, and Jesse can appoint. Kimberly Queen is in a first term. It expires April 30, 2028, and can reappoint. Danica Ophelps is in a first term and it expires 3/28 of 27 and can reappoint. And Russ Cagle, our public member, is in a second term and that term expires 5/31 of 25 and Russ cannot reappoint. Graham McPartland is in a first term and that expires April 9 of 28 and Graham can reappoint, and we have a vacant position.
Do we have any applicants for anything?
Yes. Yes, we.
We do have some people lined up. We've submitted their names to the governor's office and that's where we're at right now. So
Physician
President
and
and LD.
okay.
That was Chrissy for the record.
And for the record, this is Ann Thompson. I just wanted to remind the director and indulge myself and thank Julia. This is her last day as chair. And after today, Jesse is our new chair and Danica becomes our vice chair. And I felt extremely privileged to work with you, Julia, over the years. You've just been just a joy to work with. So I should be selfish and take one and thank you.
Thank you.
Her.
It's been an honor to work with the Oregon Health Authority and the Exolo team. We've been always responsive, helpful, and really fantastic team to work together and coordinate.
Thank you. And you've been through a couple of directors too. then.
Yeah. Really good.
Okay,
Great to me.
thank you. Okay. Moving on, unless anybody else has to say about Julia. Only good, we're only doing the good. The next item is the licensing fiscal statistical reports. In fiscal year 2025, in quarter one, we've issued 561. In quarter two, we've issued 289. Quarter three, we've issued 640, and so far in quarter four, we've issued 50. And just for everybody's knowledge, we run on a fiscal year, and that is from July 1 of any particular year to June 30 of the following year.
Ma'am?
Yes.
Excuse me, if I may, if you'll notice, board members and members of the public, we have had an enormous increase in licensing. I noticed it last fall and I checked to make sure it was correct. Because when you're handling a lot of applications, all you have, and our applications are very manual, all you have to do is put the wrong code in and it'll come up as something else. So I looked into it and yes, there were that many and they're still very many. Our regulatory manager, Travis Shuck, asked me, where are they coming from? So I had our database person look at it, and the vast majority are applying from out of state.
They're telling them.
But I wasn't sure what the basis of it was, but yes, we checked the statistics and they are correct. Thank you. Thank you, Bob. Sorry, David.
No, you're fine. And that was Ann. Licenses renewed in the same fiscal year. We've had 800 in quarter one of 2025, 713 in quarter two of 2025, quarter three, 611, and in quarter four, 39. License by age and gender. And I am on slide 13 for those of you that might be following along. You can see that the field is predominantly those that identify as female. Licensing trends, that again kind of backs up Ann's comment about how we're getting so many applications and a lot of them coming from out of state. We've gone from quarter three from average of 2,359 to 2,980 on average.
This is Doctor. Do we have data as to the place of type of employment these dietitians engaged in from the survey that's done, the private practice or in the clinicals, or must be in the work?
This
The work survey.
work survey. We don't have that now periodically, and I think you've probably seen one that I brought you before. That information is compiled and released in a report. And it's funny that you mentioned that. We're about due for the next round. And that gives a little bit more information, mainly the gender, ethnicity, that kind of thing. As far as where they're working, that's a little more tenuous.
But type of work.
Type of work, that might be something that they're, and again, they work separately from us. So what they've got going on in their little factory, I'm not really sure if they've changed some of their criteria, if they're gathering more, they talk about real DSOG, about race and ethnicity. I'm not sure if they're expanding that, but we are going to get a report, I think probably late summer is about the next release. But we don't gather workplace information, we just have a mailing address on the app.
Okay. And then on slide 15 are the board's financials. In 2025, we had a beginning balance of 236,074, revenues of 186,103, expenditures of 118,609, and net operations 67,494 with any cash balance of 303,568. So the board sitting pretty good. And
Explains the
influx.
$100,000 increase.
Yeah, it's those license, the increase from the state licensees. Okay, any questions on the director's report from anybody on the board? Okay. Next item on the list is the regulatory report. Travis Shuck, our regulatory manager.
I am here.
Yeah.
Hello, everybody. My name is Travis Shuck. I'm the regulatory manager here at HLO, and I'm here to talk about the regulatory report. So the regulatory report kind of has three sections to it. the cases that the one far to right is the cases open and closed, their status. As you can see on here, we have two biennium. On here, we have the 2023 biennium and we have the 2025 biennium. Now, the 2025 biennium, we are mostly through. We have a couple of months left. It goes through the end of June. So that is where we are. And for that time frame, we've received 6 complaints. 5 of them are still open. 1 of them is closed out. And then for the 2023 biennium, you can see we received 4. We have 1 still hanging on. So you know that is in the process of trying to get it wrapped up, but it's not quite there yet. So that's what you're seeing there. You can see that we've received a few more complaints this biennium as compared to the last biennium. It's not significant, but we have a couple of more months. I don't know if that number will change. Nothing super significant, though. Then we have the complaints by type. You can see the licensing concern services provided. Those are the 2 different types of complaints, the big categories that we've put them in. There are other categories out there, but this board has only had those 2 types of categories that come in. Licensing concerns they could be anything from somebody's practicing without a license. As you can see, there's 1 over on the left side in the cases open and closed status. You see 1 unlicensed, or probably actually 2 unlicensed dietitians. So 2 of those 4 are that, and then 2 others could be simply somebody's working with an inactive license or something, or that was the allegation. And then you can see services provided, 6 of the 10. So we're revolving around some type of service issue, either that could be somebody wasn't, properly servicing their client. There could be, could be ethical situations. It could be confidentiality situations, or the type of situations that come up with this board. And then you can see the complaints by type. Actually, only 1 of them was specifically from a client. The other 9 were other. That's kind of a high number. None of them were anonymous. So that's kind of what you're seeing here on the regulatory report. Does anybody have any questions about regulatory or the investigative process in general, or any of the numbers they're seeing on this report?
Just what's the definition of client, if I may? I don't know what that means.
Yeah, I know these things seem like super straightforward, but sometimes they are not. So that's a good question, because it can mean different things. Some boards, client can be most of the time the client is a minor, right, a kid. So the kid never complains for themselves, but the parent may be considered a client, right, or their advocate. Somebody who's their guardian. Now, in this board, typically the client is the client, the person who's receiving the service, not a representative of their. If some other, like maybe let's just say a client was being seen by, or somebody was being seen by a dietitian as well as being seen by some other type of care provider or doctor or something like that. If that other care provider was the one who sent in the complaint because the client brought something to their attention, that care provider would be an other, not a client. So it just depends on who actually sends the complaint in. I know it's kind of it's not the best, the most nuanced way, I should say, of defining it, but it just gives us some idea of if the clients themselves, the people who are actually receiving the services, are complaining, or are they coming from other sources. So.
And just another question, if I may. So other is, there's 9 of them. Do you guys, I know you report out to us as other, but within your particular agency, do you look at them in specifics, or are they just all thrown in as others?
Well, so yeah, this is basically a report meant for public consumption. There's no confidential information on this. We, of course, on our end, see all of the details of the complaint. When the complaint comes in, we have all of the We have all the names, we have all the relationships, we have all the information. When we do the investigation, we'll talk to the people, get statements. We'll also get records and things like that. Sometimes records from just the dietitian, sometimes records outside the dietitian, medical records, things like that. So all of those things, we see all of that information on our end. Whenever there's a situation where an investigation has some type of allegation, like, so if we go through it and we find that there's definitely a violation, or we think there might be a violation, or it's even kind of gray, we're going to bring that case to the board, and in executive session, we're going to give the board all of the details as well on that particular case. And then the board will be able to look at it, and they'll be able to determine, does the board feel, do you all feel that, that violation did occur, that the conduct did constitute a violation of your laws and rules or ethical standards, and then what to do about it. But that's all done, and those details are all seen outside of public session, because they can have pretty highly confidential information in them. So this report is just giving us an overview of what's going on, and how many complaints are coming in, and kind of where they're coming from, and the broad swaths of what the complaint types are. And then when there's cases that need to have a determination made, they're brought, and the board sees those in detail.
Thanks so much.
That answers your question, yes?
Yeah, absolutely.
Okay.
They may be asking questions to having a little more understanding, considering what's going to happen after today. So, thank you.
Yeah,
And-
yeah.
So I'm not moving into your.
Yeah.
Yeah, and if some of the legislative stuff actually comes to pass, then we could see a different landscape. So.
Yeah, thank you.
Just a quick question, this is Brockdorf. Do we, based on the 10 people who currently have open complaints, do you know percentage how many provide care in the virtual versus face-to-face environment?
That's not something that we have been tracking, although with those huge numbers of out-of-state people that have obtained licensure in Oregon, I think that that's probably indicative of people doing telework, needing a license to do telework with clients. That's what I think I'm inferring from those numbers.
That answer, if you
Yeah.
following up on that.
We have not started to receive, I can just tell you off of my memory from complaints that have come in, we have not really started to receive telework complaints from this board, I don't believe. I think we've had a few questions come up, but I don't know if we've had any complaints. But it is something to watch for, and I can oftentimes when I'm preparing, I kind of look at the complaints and see what we're doing. So in the future, I can take a look at. There's only 10 complaints out there for these two bienniums to look at. So I could take a look at those and see if they are involved telecare. I can say that I know that a couple of them, the appointments that some of the appointments were telecare, but I don't think that they were out of state telecare. They were appointments that were done. Some of the appointments with clients involved that type of appointment, but I don't think it was somebody like in Kentucky doing telecare with somebody in Oregon. Not that kind of telecare, if that's what we're talking about.
Appreciate it. Thank you for your report.
Mm.
Any other questions? Okay.
All right.
Thanks, Trappist.
Yeah, thank you.
Okay, next item on the list is the policy report.
Okay, well, good morning again, Chair and members of the board. For the record, my name is Ann Thompson. While this legislative session has been dense at the very, very least, and there are quite a few bills that affect HLO, giving us new programs, new license types, provisional license types, changing all kinds of things. I wanted to call to your attention for the sake of brevity, there's two big ones. One that changes the dietetics universe in Oregon. And it's Senate Bill 1174, and yes, here it's, and I couldn't get a staple through it. It's okay. This particular bill, which had a work session on the 8th of this month, changes the entire landscape. It changes the board. It adds a nutritionist license. It makes dietetics in Oregon, as now it is a Title Act, into a practice act. A Title Act is you can't call yourself a licensed dietitian without a license, but the work itself is not protected, which is why people try to sell you things at health food stores. Practice Act is like medicine or law, where you cannot do the work without a certification. It creates a separate license for nutritionists. It dials down on medical nutrition therapy. It addresses telehealth. It gets really down in the weeds on what the board would have responsibility for. The initial bill even tasked the board with comparing foreign credentials with American education, which is something that is so complex. We now have folks go out to private companies and have their education analyzed. A subsequent amendment took that piece out. With a sigh of relief. But the rest of it puts a lot of work on the board to determine programs, to determine it. There's a lot. Let's just say there's a lot. We've had 2 amendments so far, but nothing has been gathered up. It hasn't gone into, it started in the Senate, and it has to pass not just time steps, but committee steps. It has to do certain things by certain time. During the work session, we put a fiscal impact on it because it would require an awful lot of DOJ time, HLO time. So there was a fiscal impact on it. It was just posted as the hearing, the work session was being held. And so Senator Patterson, who used to be on the Nursing Home Administrators Board here at HLO, saw the fiscal impact get posted by legislative counsel and or LPRO, I forget who does it, and said, whoa, I guess we have to send this to Ways and Means. Anything with a significant fiscal impact has to get routed through Ways and Means. They're the money people. That removes some of the time elements. Other committees, if a bill goes into a committee and it's not moved out by a certain time, it's dead. Ways and Means is an indefinite time period because they don't want to put pressure when they're talking about money. So I haven't seen it posted to Ways and Means yet. But there it is. Any questions on this particular bill? It's a heavy read, no question about it.
It's a little great.
It is a long read. I will tell you though, a good bit of the back, there are things called conforming amendments. If I can take a slight civics detour. And that we only have the power as a government agency, we only have the power to do what we are specifically granted the power to do. So unless the conforming amendment that allows us to issue a renewal is looped in, we may not be able to do it. We've had that happen before. We do have overarching statutes that are kind of going to bootstrap those issues. But if they don't specifically add the new board to, say, investigative powers, disciplinary action, all the buttons and levers that help us do our job, they don't include all of those. Whoops. And we've had that happen before. You know, where we couldn't issue a renewal. One of our new boards came on and HLO was not granted the authority to issue licenses. So the board had to meet every week and review applications to issue licenses. So it's all of those sort of adjunct powers. So the whole back of it is mainly the vast conforming amendments that'll allow us to do our job. The other bill that I wanted to call to your attention, I've been bringing it to all my board's attention, is Senate Bill 8.
Question.
Oh, yes, Kimberly.
Hi, thank you. Sorry to interrupt, but I just wanted
Not at
to
all.
kind of check in. I had 2 sort of questions regarding the financial impact. Number one, is the financial impact just something that's going to be like a one and done? Or number 2, would licensure, since it's being increased, offset that cost where the board could potentially hire somebody to fill the gaps? Are those things that are being considered also?
This is Bob, if I may take that. So the fiscal impact is what we're envisioning the increased workload would be. And because of that, we have requested additional personnel. What we get, you'll know when we know. So, because it'll have to go be approved by the legislature, and then there's other hurdles. But to answer your question is, yes, we're aware of a potential of a, not even potential, of a fiscal impact. And we've worked with our government relations folks to ensure that the appropriate people at Capitol receive what we believe that impact will be. Does that answer your question?
Yes, thank you. I know there's some unknown still, so thank you.
Right, and one of the things you have to consider, not just when you talk about workload, think of the opening the mail, think of the phone calls, think of when you're changing the universe like this, where the investigations were simply, were you misusing the title? Now it's going to be a practice. Were you practicing medical nutrition therapy? What did that look like? When you're now enforcing a practice act, your investigations are going to go way up. Your complaints are going to go way up. The ripple effect onto DOJ costs, which can vanish your money as fast as anything. So it's not just addition. We're getting a new license. It's an exponent. Everything gets bigger, if that makes sense. So yeah, so we're trying to make sure that we can absorb the work and maintain the quality control standards that we feel licensees deserve. We don't want to take, rob Peter to pay Paul, so we want to make sure we can absorb this in a thoughtful and fair way, even though the bill goes into effect on January 1st, 2026, which
It's really fast.
well, yeah, along with about 9 other bills that all have the same deadline. It's not as bad as last session where we had to do something, we couldn't act on it until September 21st, and it had to be in place on October 1st. So we had like 8 business days. That was really a rabbit out of the hat. But this is a lot. So, but thank you for the thoughtful question, Kimberly. That's great. Yes.
I happened to download the financial impact thing.
Oh, the fiscal,
Yeah,
yeah.
fiscal impact. So this may be relevant or not. So the increase in licensure, licensed by out-of-state people will continue unless a session or two down the road, a compact bill comes into play and is passed, because we do know there's now 8 states that have passed the dietitian compact. If and when that happens, those out-of-state licensee people would only have to, and if they're from a compact state, would only have to do the compact and not have an Oregon license. That makes sense?
Yes.
Okay.
It does.
So it just changes, it potentially
Yeah.
changed the workload and finances of bringing in more money from out of state.
Right. And when that time does come, we will.
Yeah,
be-
have to redo everything.
Yes.
Okay. Yeah.
We'll
I
have
don't
to do
know.
our own fiscal impact. What you got there is an abbreviation.
Yeah.
Of what all the work that.
Yeah,
you know,
no, I understand.
So,
And, who knows if it'll even come up in a legislative session down the road.
yeah, each time a bill comes to us and we see that there's going to be a financial impact, we usually end up having to do a fiscal.
Yeah.
And then for those of you online and maybe in the room that don't know, HLO is another funded agency, so we don't get any general fund monies. And so we have to get our crystal ball out and look into the future of what expenditures we may have and do it appropriately. And the difficult thing is we have to go through a process called the 333, which is from Senate Bill 333, to increase fees. But to decrease, we can give a discount on renewals, for example. So we may overshoot in the beginning, but then as our fiscal analyst tells us, hey, you've got way too much money, we're not a bank, you need to decrease it. we will roll back the fees.
We have some discretionary discounts
Oh, okay.
that we can apply. It is very, very difficult to establish a new fee or raise fees, because Oregon is all about transparency, inclusivity, and frugality. But we can offer a discount, and we do that. We try to make our boards right size, where they have enough of a cushion. If you have a really bad case, your money will disappear. You could lose $100,000 in the blink of an eye, you know, if you had a case that went all the way to the Supreme Court, and we have had cases go that far. We win them, but the most we can recoup is $5,000. And in the legal fee world, that's a cup of coffee. So we try to make sure that we have enough to cover you, but if you're taking in a lot more than you need, then we can offer discounts and things like that. Now, some boards, the world has changed, and maybe they're getting too low, and then we might have to rescind some of those discounts. But that's what we constantly keep an eye on to make sure you're right sized. Does that make sense? Questions? Okay, well, that brings me, speaking of right sizing, that brings me to the other bill that's gotten my attention, Senate Bill 800. And I'm mentioning this to all of my boards, even though this bill is a bit of a sleeper. It had a hearing and then it's just been sort of dormant. That doesn't mean it's dead, but it's dormant. It was a bill that was prompted by and asked by our governor. And it essentially links licensure and renewal of licensure for any profession with tax compliance. And what that says is any organization that issues a license, somebody applies, they would have to, that individual, along with their application, would have to go on to the Department of Revenue, OR, using a portal that they promised to build, and download, stop laughing, Rose, download a certificate of compliance showing that you are up to date with your taxes. If you are, and it has to be within 90 days of your application. So there is a time element on there. If you renew, you have to do the same thing. We are making people aware of this because if they say you're out of compliance, your license is suspended. You cannot work. And they said that this is a friendly way to get people to come to the table and stay compliant. And it essentially makes HLO and other agencies that issue licenses sort of an adjunct arm of the DOR. And having to check to make sure someone's in compliance, making sure that that 90-day window has been met is really going to slow us down. So it's something where it would be enough of a lift on licensees and us, and it would affect how we do business and how quickly we can do business. This is something that I've been bringing to everyone's attention because it's even though it's kind of quiet, when there's this much power behind something like this and they're that enthusiastic about it, I feel like any licensee should have the opportunity to, if they feel strongly about it and how it would affect their work, their businesses, to be able to testify if they wanted to. I mean, obviously the first hearing is over, but you can write to the Senate committee chair and just send an email. Not as a board member, but just as an individual, just so that you know this is out there, because it would have an impact on everyone who makes a living with a license. And I know some of the League of Oregon cities came out against it, saying we have subcontractors, it's dominoes, somebody doesn't pay somebody, and the next thing you know, they're a little bit behind because they'd rather make payroll. If they can't work, how are they gonna ever get going? So Yuli, I see a thought bubble above your head.
Where is this is Proctor, where is this at? So it went through the committee hearing, now is it in the House side? Did it get
It's still in-
was it heard in the Senate floor?
And it has not made it that far.
Okay.
It
So
had,
still waiting to be heard on the Senate floor.
yeah, it's
third
something where
hearing.
it's not what we would call mobile. I mean, we have another bill that's creating a dental lab program within HLO, and it's already gone through the House side. It's been heard had its third hearing on the floor, and now it's jumped over and it's scheduled on the Senate side. This one, when it was introduced, the committee that introduced it, the energy in the room was negative. There was a lot of, mainly because the Department of Revenue hadn't brought a lot of organizations like us to the table. saying, how will this work? I know the legislature does not like to mediate squabbles. They want stuff that comes in front of them to have already been talked out, right? However, because this was a governor ask, and it's not, I don't trust it. If you do this long enough, you fear the zombie bills, the ones that you think are gone and it's fine and you can relax and you sit down next to it and then it wakes back up. So I just felt this was important enough that even if it's not really going anywhere, to make you aware of it and know that if this is something that the governor wants, it may show up again.
Yeah.
And just keep your ear to the ground. So if it's important to you, yes, Jesse.
So if I read this correctly, it's only anybody in this state and up to date with the taxes of this state. So any of those out of state folk wouldn't have to do that.
That's my understanding. Well, it has to do, yeah,
Because
with
they didn't check on it.
yeah, and from what I understand, it has to do with wage type taxes. If you owe on some property or something like that, you own a building somewhere, that would be outside of it. They also promise a hearing process. If you're debating what they say, they were going to create a process by which you'd have an expedited hearing to try to straighten that out.
So really, this is companies haven't kept up with their employee taxes or paid all that stuff.
Individuals.
Individuals.
If
So
you
if you're
are
a contractor, independent contractor too. And personal.
Yes.
Personal taxes or the Multnomah County tax that everybody's in every.
Well,
That's all right.
and something that Bob likes to bring up. about
Going to.
Yes.
Yes, because Bob likes, I can mention this and then he reminds me.
Yeah.
The point that the DOR made was that there are certain groups that are below what they considered an acceptable threshold for compliance. Now, I don't know if they're aiming at people who work for cash, people who don't keep up that way. But what they were planning on doing, the rules, so we don't have anything to look at, is finding a group, say tattoo artists or nail techs or construction people who are not, they're below.
Back?
Please mute you. Anyone who's online, can you please mute? Thank you. Anyone who falls below that threshold, what the DOR would say is, okay, everybody who's in the construction business has to get this certificate of compliance. And then after 5 years, if they rise above the acceptable threshold, then the lens will turn to something else, right? So they're going to be looking at certain groups. The reason I'm mentioning it to everyone is we don't have those groups identified yet. So if there's a potential, I feel it's my responsibility to make you aware of it. Thank you. Thank you. So and do you want me to do the affidavit or do you want to handle that?
You can tag team.
Oh, okay. So if you don't have any more questions about the legislation, anybody online, please reach out to me. I'm more than happy. I'm not going to send you to the website unless you really want to go there to let you know how things are going. Again, your bill has, I believe they said verbally been moved to Ways and Means, but I've not seen that confirmed on the OLIS website yet. That actually brings the other part of policy is something I spoke with Jessie. She was nice enough to talk to me about this. The Licensed Dietitian Board is the only board at HLO that does not charge a fee for an affidavit of licensure. And what that means, a lot of dietitians have licenses in multiple states. And to get a license in another state, and we have to provide primary verification to that state on behalf of that individual, saying, yes, they're a licensee here and they're in good standing, right? That takes staff time. Every other board, we have 19 boards and programs, has a fee associated with that, and yours doesn't. And I went all the way back in time. Our licensing manager, Tina Russell, said, we're getting more, I mean, you saw the numbers.
Yeah.
We're getting more and more and more of these. Our staff is backed up and we're not charging a fee. Can you find out why? So I went back all the way to the beginning of time and talked to Jessie about, was that ever a discussion? And no, it never came up. So we don't know if this has been a long-standing oversight, but Bob wanted to talk to you about, you're gonna get that process started, so.
If the board agrees, and Kimberly had a great segue, but we're way past that when it comes to fiscals. You know, you look at 265 and out of state in 2024, that's possibly 265 hours of staff time. And where we're other funded agency, the time is, somebody else is paying for the time, for the licensing representative to process the application, make phone calls to gather additional information. So our goal here is to bring licensed dietitians up to standard with everybody else with the fee for doing out of state licensing. And it's $50. Tina, correct me if I'm wrong, please. I believe it's a $50 fee to help pay for the staff's time that is doing this. And it's one staff member doing this exorbitant amount of processing. Jesse.
Yeah, have one act, because I don't think I asked Ann about this, and the only reason she called me is I was around when this all started. Because, I've been 30+ years. It's for, the affidavit is for anybody that has an Oregon license and then wants to go to another state, or vice versa, or both.
Vice versa.
Okay, cool. I
So if
mean,
they're coming here.
yeah.
They, or no.
No,
I
it's
got it.
only, it's only one way. It's
Yeah.
essentially they're licensed in Oregon.
Yeah, and they wanna,
And they want to be licensed in Kentucky, or they want to be licensed in New York State. And what we have to do, just like we get primary verification from the CDR, that we can't trust that you're giving us a piece of paper. Yes, Derek.
There is also the option for individuals to submit an affidavit to us who are from out of state wanting to come in state. So there is the option to do both.
and can I follow up with that one question? So if we would have to change our rules for what you said, like if somebody's coming in, we would have to require them to give us an affidavit.
That's part of the licensing process.
Tina has her hand up.
Yes, Tina.
Good morning. It is going both ways, incoming and outgoing.
And just to add to that, if someone holds an Oregon license and wants to send verification to another state, they have to go through us. If someone has a license in another state and wants to come to Oregon, they have the potential for us to verify that, or that initial state can send official verification to us.
So if I may, sorry, so the fee would apply to both ways.
Yes, if
Okay.
anyone wants us to get official verification, yeah, they have to pay that.
Okay, thank you.
In addition to license application.
In addition to the application fee, right?
So for this point on the agenda, are we asked to discuss it? Are you informing us, or we willing to take some action on it today?
We discussed it.
We can certainly discuss, it's one of those things that as one of our powers, one of HLO's powers is to establish fees, right? And if it's business need, you can understand if we asked folks, do you want to pay this? The answer is always going to be no, right? And so there's times where we have to impose fees, and we have the power to do that. But also the decent thing to do is to explain why we're interested in doing this, why it costs what it costs, and not to start the process. I mean, it's kind of, and Tina's got her hand up, I see that. It's not good politics to just say, here's your new fee. It's a good idea to let people know we're thinking about this, we really need to do it, and this is why. Tina?
This Tina. So what the problem is currently is we get an application in that want to become licensed in Oregon, and at the same time within their application, they're wanting 2 affidavits to go to other states. I don't know what the purpose of that is. So, and you're correct, individuals coming in are coming through the CDR certification. So therefore, those individuals wouldn't need an affidavit coming in here, but any of those individuals that apply that want affidavits going out would have to pay for that affidavit, but it's only one fee if they want 2, 3, or 4 affidavits going to other states. It's one fee for one affidavit when they originally asked for it. If they ask a week later for it to go somewhere else, they're gonna have to pay additional $50 fee for affidavit.
Thank you, Tina.
Yeah, so Tina, it's my understanding that if they ask for 3 at the same time, that's 1 fee. But if they ask for 1 and the next week they ask for another one, that would be 2 fees, correct?
Correct.
Thank you. Yes, it appears that right now other boards are subsidizing staff time to process additions of affidavits, and this fee would resolve that subsidy.
Correct.
And this is something that have to be done through the rulemaking process. Because it's a fee. It's not something we normally have a rules advisory committee on because the answer, we establish the lowest possible fee we can, knowing the staff time. Asking the public, do you really want to pay an extra fee? Well, the answer is always going to be no, right? So, the other thing was this would require a rule to add the fee, and we're watching this bill. And I'm going, okay, if this bill is moving really fast, this might be something that we end up folding into the bigger piece. We might do it separately, but we just wanted to let you know that that this was probably on its way.
Okay. So if somebody wants multiple fees,
Multiple fees?
well, multiple
Affidavits.
affidavits, okay, processed at the same time, is there a fee, additional fee?
No, if they ask for a few at the same time,
Yeah,
it would just be the 1 fee. But if they want like 1 and then they come back a few days later, they want another one, because once you're in there.
Okay.
And the screen kind of went dark, but Tina could give you, actually Kimberly has her hand up. But Tina, once you're in that zone, you could do an efficient job at a couple of them. But
Okay.
having to go in and start the process and get going again, that would be a separate fee.
okay, I understand that, but so there is no more complications to the person that's administrating from our board or, your association, okay? There's no more charge. There's no more extra ability to process more affidavits when they request more. You're not following me. Okay. All right, so I request multiple fees be administered. Right?
These affidavits.
Yeah, affidavits.
Okay.
And those affidavits are going to different locations. All right, is there any additional requirements from OHS or OHL to be fiscally responsible for payments to those other places, right?
It just goes out in the mail. Certified.
Just printing off more affidavits and going out to the mail. Okay, that's fine.
This is Tina, sorry. Most of them are emailed. So once we have one affidavit up and all the information is in there, we're just shooting it off to the 2, 3, 4 states. I mean, some of them have multiple states all at one time. So it's all one fee, one process for as many as they have initially when they ask.
Thank you. Did Kimberly have a question?
Yes, I think it's very standard with boards to assess a fee for doing affidavits. So I know that as licensees, it's difficult sometimes to swallow that extra cost, but really we are paying for that administrative duty. And ultimately it is worth it, especially if you're allowing, multiple affidavits to go out for one fee, I think is very fair. So that's just a statement that I'd like to add to that. And that if we want to, really be in line with other boards, I think it's probably necessary for us to do this to cover the costs.
Thank you, Kimberly. This is Ann. You pretty much quoted Tina. When Tina came to me and said, why is this missing? And that's why I ended up doing some research. I went all the way back to when this board was an independent board And I ended up calling Jesse as our resident historian to say, why has, well, but you were there from the beginning, right?
Yeah.
And say, okay, why was this not a thing? And the answer was, don't know. So it's going to be a thing, but when we're gonna be able to get the rulemaking process spun up and all of that, is really dependent on how the legislature moves and what we've all got going on, but that's something that is on.
Thank you so much. Thank you. Any other discussion on this, or can we go to the Illinois?
You do have, just to let you know, you do have a document, Bob asked our data person to find out how many we're processing right now without fees. And if you can see, there's the grid that said LD AOL count, that's licensed dietitians, affidavit of licensure count. We went back to 2022 and you can just see how many they are and they just keep growing. So we're not making this up. This is a significant chunk of staff time. So thank you, Bob.
Thank you.
Of course.
Okay. Next item on the agenda is a discussion of whether state of Illinois requirements for licensure of dietitians are not less than Oregon's requirements. Does anybody have a statement to be read? I see Kimberly's hand up.
Dr. Queen?
This is Dr. Queen. I was told that this would go to executive session. Is that true?
We're not holding an executive session.
Okay. Well, I'd just like to publicly announce that a potential conflict of interest and disclose maybe that I might have a small conflict of interest. I was contacted by the policy analyst Ann Thompson, and I was sent the policy, which I also had read, and also spoke with the Oregon Government Ethics Commission with Josh Sullivan, the investigator. And I just wanted to, I revealed some scenarios that I was a CNS, obtained licensure through reciprocity from the state of Washington. And also that there was the bill SB 1174. And then lastly, I work for a nonprofit, NUNM, that graduates master's degree nutritionists that offer the CNS credential, the education, and that basically fulfills the requirement and eligibility to take the CNS exam. So Josh sent me information on the policies. Basically, he stated that I would not be in conflict with the first issue of reciprocity because I really have no financial benefit, or it's not a detriment to me or any business which I'm associated with. So therefore, there is no potential conflict with that particular issue. However, there might be a slight conflict because I do work for a nonprofit that offers the curriculum or the education for CNSs to sit for the exam. And so he just stated that I should make a note of that to make a statement of a potential conflict, but I would still be able to participate in the discussion and vote on the matter. So I just wanted to give good cause for me to proceed despite this minor conflict. And I really feel that it's my role and duty as an LD member to act impartially and look at the objective evidence that's set forth. And that also I would potentially argue if this situation were reversed, if it were RDs in the same situation, that others could potentially have a conflict. So, but I really feel that I don't have any advantage financially or disadvantage. I have no family member involved in this decision, and I would not be gaining in any way regarding the situation. So I just wanted to put that out there.
Thank you very much, Dr. Queen. This is Bob, and I will turn it over to Derek, our qualifications analyst, who's in the room with us. Derek.
Hi, everybody. For the record, my name is Derek Foltz. I am the qualification analyst here at the Health Licensing Office. So in your material, you will see two different issue statements. The first one is a breakdown and comparison of various licensing requirements for both Oregon and Illinois. So what we would like from the board after reviewing them is to have a discussion and see if the board feels that the licensing requirements for Illinois are not less than Oregon's requirements. And if they are, just provide an explanation as to why you guys feel that they are not equivalent. The second issue statement is a comparison strictly of the CNS exam and the RD exam. So we can start with the Oregon versus Illinois. And just a little background about that. We received an application from an individual who came through reciprocity, was licensed in Illinois, and was issued a license here. Afterwards brought to our attention, it was determined that it needed further review to make sure that Illinois' requirements are actually not less than Oregon's. So that's where we are bringing you guys into the discussion. If you look at the issue statement, I have it broken down in several different areas, sort of the different requirements to obtain licensure in both Oregon and Illinois. So you'll see a section for education, a section for the examination, a section for the supervised experience, and then lastly, the qualifications of a supervisor. So when you look at this, hopefully you have colored copies because there is color coding on them. The language that's highlighted in blue, that comes directly from Oregon statutes and Illinois statutes. The language that's in green comes from Oregon Administrative Rule and also Illinois regulations. So before you guys go into discussion, there's a couple different ways you can approach the comparison. The first one would be doing an apples to apples comparison, where you are looking at each requirement of the states. So an education to education comparison, an exam to exam comparison, etc. The other way the board can go about it is doing an apples to oranges comparison, and that would include just comparing the states' requirements as a whole. So we'll be doing a breakdown of each one. You just overall as a state, do you feel that Illinois' requirements are not less than Oregon's?
Thank you. Can I ask you a couple of questions before we get into discussion?
Absolutely.
So the reason you chose Illinois is because the applicant was from Illinois.
Correct.
So there are seven states licensures who include nutritionists. The other 40, because there's 3 of them that do not include nutritionists because those legislations only license dietitian, which is what ours does in this state. So those, do you have background of what happened in Illinois? I do.
I don't.
Okay, so they were going to sunset their licensed dietitian a few years ago. And in order to that not to happen, there was this whole big thing about including nutritionists too. And so it was a compromise not to lose their license. But our legislation and our rules specifically say licensed registered dietitian by the Commission on Dietetic Registration. It does not include those other examinations or anything else by our law or our regulations. So I am not sure why we're even talking about whether this is less than or not less than. They are different. It's like licensing naturopaths in some state, and it's different than the state of Oregon. They're different. So I'm not sure that I can even have a discussion about less than, because I don't know what that means. I just know what our law states and what our rules state. And I know Illinois has a different law and they have different rules. I don't know how you compare the two, because as far as dietitians go, there's no apples and oranges. I mean, they're apples and kumquats, frankly, as for the laws across this United States.
So by laws, are we referring to more of a scope of practice or actual licensing requirements to obtain a license?
Well, since we're just a title act in this state, we have no scope of practice except what's listed in our rules, and it's really pretty, loose. But as far as the law goes, it is specific about a registered dietitian and the Commission on Dietetics in this state.
Doctor, is registered dietitian or is it because they can be non-registered dietitians and be licensed dietitians in Oregon?
We can't.
Do we not have members who are licensed?
We've done that, but based on our law and our rules, it says we only do registered dietitians with the Commission on Dietetics.
It's our statute. Could you please help me to weigh in on that?
Yes, could you clarify the question? Because
My understanding, just correct me if I'm wrong, you're saying that only RDs can be LDs in Oregon. My understanding was that you do not have to be RD to be LD in Oregon. I want clarification. on that, please.
well, you have to be certified by the CDR or have everything you need to be certified. And we had one person do that where because of COVID, CDR wasn't, processing in time or whatever. And they literally brought in everything they needed to be CDR. Or you can be CDR, but you also have to have, let's see, it is a Title Act.
Brown, I understand that actual RD or RDN is not a requirement to be LD in Oregon. Is that accurate?
How about the title itself? Please talk amongst yourselves. It was my understanding you're either CDR, you have everything you need to have to be CDR.
Right.
But you have everything you have to be CDR is not RD, does not have the title of RD. So you can be LD without the RD.
Pathway one, we love our pathways here at HLO. You can qualify through an exam. You have to have a baccalaureate or post-bac from a regionally accredited college or university in the US in human nutrition, dietetics, foods and nutrition, or food systems management. That's straight out of the statute. Submit evidence of a passing score on the CDR, which may have been taken no more than 3 years preceding the date. And submit evidence of 900 hours of a board-approved program of dietetic experience under the supervision of a licensed dietitian, and of course, pay your fees. You can qualify through reciprocity, which is notwithstanding what I just said. An applicant who is currently licensed under the laws of any other state in the territory must fulfill the requirements of subsection 1(2). And that's essentially fill out an application, pay your fees, and show that the requirements to obtain the applicant's license from another state were not less than those in Oregon. Or you can a qualification through equivalency, which is notwithstanding the requirements. An applicant who is currently registered with CDR, essentially, you just show up with your CDR in good standing, pay your fees, fill out your form. And that's how you do it.
So RD is not required. The actual RD registration, that's an exam is, but RD is not.
But to pass the exam, once you pass the exam, you become an RD.
That's a different matter. That may be the test. That is a test. But the actual statute do not say you have to have RD.
That is not mentioned.
And RD is not mentioned in the statute. The exam is, RD is not.
Which is good because we changed and added the RDN. I mean, it's
Yeah.
good that it's not. So anyway,
Yeah, and when they.
but it is passing the registration exam is clearly mentioned by the exam
Mhm,
that's administered by the Commission on Dietetic Registration.
that is correct.
So what are,
That's what we have, this is Bob, that's what we have in rule, but I believe the statute says an exam.
Pass an examination prescribed by the office.
Prescribed by the office, which is the board approved.
Right,
Yeah,
which is the RD one.
Right.
CDR.
CDR, sorry, yes.
so in this, is Illinois equivalent in this broader, so with Illinois, the exams that are included to get Illinois license could be the CDR or other exams.
Correct. So Illinois accepts 4 different exams for licensure.
So we are trying to determine whether or not essentially this is a discussion and a vote on whether or not we accept Illinois accepting other exams. This is what it comes down to.
Correct, yeah. So if you were to compare Illinois' examination requirements, you would have to look at each exam that they approve. And you would have to determine if each exam is not less than for its exam. If one of those 4 exams, or I guess one of 3 different exams is less than, then as a whole, Illinois' requirements would not be equivalent to Oregon, because someone could get licensed
And
under
in
an
the
exam.
scope of this discussion, it's gonna be impossible to go do this work. Right now, we're just trying to look later on point on the CNS exam, compare them to the CDR exam. So if we are going to be discussing without really putting apples to apples, we really cannot be voting on this topic, make a decision on the comparative, if this what it comes down to.
What do other members think? I would like to hear from people online as well.
Members of the board.
Danica, or Kimberly?
It was my understanding that Pathway 2 did allow for that reciprocity to allow other than the CDR exam. So as far as this apple and oranges situation, I think that Illinois is showing that there is some good evidence of comparison of the exams, and that they are making and upholding individuals responsible for showing eligibility. And even though our Oregon law, it depends on what pathway you're choosing to kind of cherry pick the language from and what side of the fence you're going to be on this. But we have to look at the facts that there is some good evidence that these exams are either equal to or above the CDR exam.
Thank you. Okay.
No, I agree with it.
Oh, you agree, okay. Danica, do you have any thoughts?
No, I agree too.
So I'm not gonna argue the exam stuff because I don't know their exams. In the state of Oregon, we're a licensed dietitian LD. In the state of Illinois, you're a licensed dietitian nutritionist. They are not the same. And from, if I may, as a former hirer of dietitians, probably 100, 150 of them, it will really human resources in large organizations will be very confused if a nutritionist who has an LD meets the requirements in their organization by looking at just the LD. It'll be very confusing because they are not, it makes no, I have a difficult time having somebody that's not a dietitian, whether they're an RD, LD, but can be a nutritionist. Because in fact, if you look up the definition, all dietitians are nutritionists, but all nutritionists are not dietitians by scope and how they function.
I would argue with that. I'm sorry, excuse me for interrupting. Actually, in education and curriculum for nutritionists, they learn dietetics. And the word dietetics, I think, needs to be explained that it is part of nutrition. And they are learning dietetics in the educational curricular program. And they are practicing dietetics. They're doing vitals, they're doing anthropometrics, they're doing assessments. It is equal. They're doing the nutrition care process, which is dietetics. They are learning food and service also in their education. So I would argue that the word dietetics, yes, people are really confused about that definition, but still it is something that nutritionists learn, and that we need to educate people that we are doing dietetics when we practice.
Thank you, Dr. Green.
Just to add to that, part of at least my confusion is looking in other states as they use the term dietitian and nutritionist relatively interchangeably, or they will call themselves dietitian nutritionist, whereas we just use that one term. So for me, someone who's not in the field, that can cause some confusion. But to follow up with you, Jesse, when you say Illinois' license is not equivalent to Oregon, is that strictly because of the name being used, because of the education required, or because of?
Because their license, which is, may I respond? Yes, okay, sorry, I never know this. Because their license is newer than ours and they incorporated nutritionists. Just like the bill that's now in front of the Oregon legislature is drafted to include nutritionists. I mean, it will have a licensed dietitian and a licensed nutritionist component. But we recognize, and I don't disagree, Dr. Queen, recognize the need for licensing nutritionists. My difficulty is what we currently have now, which is we license dietitians. We don't license nutritionists by title act. They're not dietitians. And it's where we're at in the current state. I think the future state, if this goes through with all the problems it's going to have, and we've talked about that, will make that easier and clarity and will afford a route for nutritionists to be licensed in the state, which they should be.
Listen, brother, I think, just reading and looking at this information, that what's in front of us is to see if this criteria, regardless of what they are called in the state of Illinois, does individual who has this license, whatever it's called in the state of Illinois, based on the criteria the state of Illinois has to grant a license, can we look at this professional and say they are licensed dietitian, can be within the scope of licensed dietitian, even they have the title of licensed dietitian in the state of Oregon? So that is a question. To reflect on the concerns that it may be confusion to the larger institutions, I find that when it is a confusion or concern to other parties, these other parties will be testifying in present and making public comment. Absence of this public comment communicates to me that this is not relevant enough topic for them, and perhaps this is not a concern. All of information of what will be discussed in the board is available to the public, and if parties are interested to weigh in, they are very welcome to weigh in during the public comment. And do we have anybody from institutions who would like to weigh in? I don't know. Do we?
Nobody's reached out
Okay.
to me regarding public comment.
Yeah, thank you. So that perhaps, or perhaps is not a concern to others. As of right now, looking at this comparison, looking at the quality of examinations, including the CDR and non-CDR examination that is comparable to CDR, or maybe perhaps even more depth at sometimes, I think maybe we can, I would suggest board would, either add to discussion or somebody make a motion to vote.
Well, I guess my question is with regards to the issue statement, the first issue statement. Is the Oregon requirement, excuse me, the Illinois requirement equal to the Oregon requirement, or are there things missing from the Illinois requirement to make it not equal? And that's, I think that's what we're trying to get to, Derek.
Yes.
Because if you compare names aside, like the chair said, if we look at the qualifications down the list, education, exam, I don't think we'll ever know what the exact questions to the exam are because it's proprietary information. Supervised experience, supervisor qualifications, are they equal to or less than?
No.
Not like that, right?
Yeah.
Would anyone like to make a motion so we could vote on that question?
Can I ask another question? Well, you can make a motion, then I'll ask.
I'll make a motion.
No, wait.
Who was the discussion?
Can you tell me where the food service systems is on this?
I'm sorry, where the, what?
What's the second issue statement? Where the food service systems is on the CMS?
So we're not talking about fees here.
Okay.
We are talking about just eliminating. So, would anyone like to make a motion to vote on this,
So the first
the first issue statement only?
I guess sorry to interrupt, but this is Derek. I guess before we have that discussion, do you guys want to do an apples to apples comparison or do apples to oranges where it's more looking at it as a whole? Yeah. Okay.
Board members? Would someone like to make a motion?
I'll make a motion to vote on this.
Do we have a second?
So this is the motion to vote on this. Yes.
Okay, can we restate the motion?
I would let you, Derek.
Oh, and
Verify.
Okay, so what we'd like is for the board to make a determination as to whether or not Illinois' licensing requirements as a whole are not less than Oregon's requirements.
Okay, thank you.
Anybody second the motion?
So that,
Second.
so Kimberly made the motion and who was the second?
Danica.
Danica, I second it.
I'll call the roll. Would you please, just for the record, just say for one more time what the wording of this motion?
Excuse me, would be for the board to determine whether or not Illinois' requirements for licensure are not less than Oregon's requirements for licensure.
Those board members who said that no requirements are not less than Oregon requirements to obtain the title of licensed dietitian. I call the roll. Proctor, aye. Belknap?
Yay.
Okay.
Aye. At Queen, aye.
Otto?
Aye.
Thank you.
Okay, so can, okay, so did you vote and you were aye? Just. Okay.
The second issue, you're going to look at the CNS examination versus RD examination. And we will need to vote on whether or not, please articulate exactly what we're gonna be voting for in that category.
So, and correct me if I'm wrong, but we want to first make sure that this CNS exam is not less than the RD credentialing exam. And then potentially, if the board decides that it is not less than, if they want to go that way, we can potentially adopt that exam by rule or.
First thing we're gonna do just to see if it's less than.
Yes,
Let's just pause on that.
Okay,
So we need to determine, the discussion right now is to be open to determine if CNS exam is not less than RD exam.
Yeah, CEO.
Yeah, CDR, yeah, thank you for correction.
No, it's okay.
A discussion. Yeah, Jessica.
Well, I'm trying to pull up my document so I can do a search and find. Can you tell me where I've read it, but I didn't find it, where the food service systems is on the CNS exam?
We're talking about one of the domains or something.
The domain 4, I'm sorry.
Domain 3 is food service system, if on the CDR exam. The domain 3 is a nutrient and health, but where is, okay.
So domain 3 is management of food and nutrition services, domain 4 is food
Okay.
service systems. Next
Yeah,
page.
yeah, I see, thank you.
Yeah, so again, one of the issues that I found trying to do comparison myself is that obviously they don't have the same domain names.
No.
CNS has quite a few more domains and the actual information listed within each domain is different enough for me that I did feel comfortable doing a direct comparison, so.
So there is no direct comparisons to specific domains between the two, or even enough language for you to do that, is that correct?
Correct, yeah, so that's where I was looking for your guys' expertise
Okay.
in the field to provide that for us.
Thank you. So I wasn't missing it.
I wanted to ask a question, kind of like a maybe expert content question to Dr. Queen. Would you, based on your knowledge of these exams, to the extent you can comment, could you please address Jeff's question if there is specific provision both in education and what exam for CNS is requiring a candidate to know to specifically to the topic of food service management?
I'm not a content expert on the exam. I would have to defer to Amy Smith. And I believe she's in on this meeting about the food service portion.
Not to do public comment.
That's a public, yeah.
Public comment, so we will need to, when it comes, doctors, my comment, just a reflection on the clinical aspect of provision of clinical care of the nutritional biochem and understanding of the pathophysiology, etiology, and clinical consideration. I see definitely not less than between the two exams. Also with the assessment by Jesse pulled up a very significant point on food service systems that at this moment, I do not see. So, however, there's, but it may be there, the baby just simply, I just simply don't have information to reflect on. Dr. Queen?
Yes, this is Dr. Queen. The only comment that I can make on that is I believe different curriculum that's offered in universities who provide education curriculum. For example, at National University of Natural Medicine, we do offer food service and culinary skills in our first semester. So I think this is going to be something that maybe is going to be difficult to see whether everybody's offering the food service, food safety issues. And so, but although again, I would say that I'm not a content expert about the recent or current exam. I only was on the initial and exam writing committee. We did not cover that particular portion.
Dr. Queen, I would have a question to each fellow team here. Can we request to have an expert on the exam to speak to before we can make any rulings and decisions on this matter? Either someone you can ask to present for us, so we can ask these more specific questions on the food to address Jess's important question.
So yeah, with the CNS exam, I was offered the ability to sit down with someone and go over the exam in more detail. It would require to sign a non-disclosure agreement, so I'm not sure how much information I'd be able to release. But definitely having a subject matter expert there would be beneficial, so they would know what questions to ask to sort of guide that conversation.
For the protocol questions, just please correct me. If we have I don't know if we do, if we have a subject matter expert who is gonna be giving public testimony, are we able to request them to present to us right now and speak to us as public, as an expert? What is the protocol for that? If there's a person.
Good question. I was thinking, perhaps, Heather Vogelsong would magically appear.
Thank you,
Good
Heather.
morning. Good morning. This is Heather Vogelsong. I'm an attorney with the Oregon Department of Justice. So if the board needs to hear from an expert before making a decision, then it can do so as part of its discussion, naming that person as to who it needs to hear from. So you can call in someone to gather some more information so that you have the information you need.
Thank you so much, Heather. So next question, do we have in the public parties an expert, who's that Amy, who is that, could you please turn your camera on?
Sorry, yes, Amy Smith, and I'm the Senior Director of Certifications for the American Nutrition Association and the Board for Certification of Nutrition Specialists. So I am the expert on the CNS exam.
Thank you so much. So do we need to, can we ask Amy right now? Just want to make sure for the protocol in order. Can we ask Amy right now to weigh in after Jesse makes a comment?
I believe that was ahead.
So we don't have, the Commission on Dietetic Registration does not have a representative to be an expert from their perspective on this call. So point of order is that, I mean, like years ago I was on the commission.
Are you there?
Well,
You really are.
well, that's a difficult. Anyway, point of order, is that appropriate to have someone that is, I didn't know what Amy's qualifications until she just said so, which is she's on the commission and she's, you know, the person in charge of the exam. That's a different level than even I would want to represent. I think, I mean, like I said, I didn't know what her qualifications, and I don't know that anybody, I know no one contacted the Commission on Dietetic Registration, so just a point of order.
Thank you. Jacob?
Robert, we had a discussion regarding the comparison of the educational units and of both of these. And what did we come up with?
You can bring it to the board.
Yeah.
And a lot of us can't make a decision on their own.
Yeah.
So, as the board, as a member of the board who is, and most of us here have a lot more familiarity with CDR exam. Many of us, that's for CDR exam, not all of us, but many of us. So we have at least like a background knowledge, but we have no knowledge and limited knowledge of the CNS exam. For my education, I would find it valuable to hear from Ms. Smith as far as this one question, because we are not questioning whether or not CDR exam is checking the food service system knowledge, but we do not know whether CNS exam provides that type of testing. So I would call on Ms. Smith to please comment and address, because Jesse asked very valuable question. I really would like to know answer to that question from the CNS exam content, whether or not it's been tested. Amy Smith, please put on your camera and address.
Sorry, I'm unable to turn on my camera, but I can use my mic.
Okay. Go ahead, please.
So the question was around food service systems. Am I correct? If that is covered in the CNS exam?
Yes.
Okay, so the discussion of food service systems is not part of the CNS exam explicitly as a domain, because it is not an area that the CNSs work in usually directly. So we're covering menu development as it relates to medical nutrition therapy, specifically for the conditions that are listed in domain 6. As far as the sanitation and safety, it is going to be covered in public health, which is domain 7. And then the other issues of equipment and faculty training, production, distribution, we do not cover those things explicitly, but we do cover those topic areas in domain 8, which is practice management.
Let me please make sure I understand you correctly. The menu development is covered in, repeat please what domain is menu development covered in? M&T.
It would be part of, so menu development would be, menu development would be specific to a condition state. So it's going to be part of the medical nutrition therapy domain, which is domain 6.
M&T domain 6, the sanitation safety domain 7, and equipment facility planning practice, it folded into your practice domain, which is domain 8. What about the components of procurement, production, distribution, and services? Please comment on that.
That is not part of our exam. It is not something that CNSs do necessarily in their job. So we're not.
Jesse pulled up domain, have a more question, and domains, actually, Jesse, would you mind please ask a question?
Yeah, sorry. So I was trying to do search and find on my computer. So on domain 3, which is management of food and nutrition, includes functions of management, human resources, financial management, marketing, quality management, and improvement. I could not find, I found quality under one of the domains, but I couldn't find those others. Are they included somewhere?
Are they worded differently?
Functions of management, human resources, financial management, those would all be things that are in the domain 8, which we consider practice management.
So do you have a definition of practice management? Because those kinds of words or what that specifies here does not seem to
I mean, it's
include-
covering anything that has to do with compliance with ethical standards, licensure, certification. So, you know, we don't, marketing is, you know, not something we cover on our exam because our exam is completely clinical. So we're not covering questions that have to do with marketing or human resources. We're covering just things that are related to medical nutrition therapy on our exam, not necessarily the things you would need to know outside of medical nutrition therapy, as those are not things that we test on. Human resources and marketing are not something that we test on. It's a clinical-based exam.
Question, Jesse, to the best of your knowledge, I have not taken that exam for many years.
Well, I'm longer than you, my dear.
Not that long.
Yeah.
So, like human resource
Yeah.
and financial management, are those kind of specific umbrella that they actually are the exam test on?
Yes, yes,
Are right now?
Yes, yes.
Okay,
So you have the domains and the percentage. I will declare, don't think it's a conflict of interest, but it may be, and let me do that. I am on the board of editors for Eat Right Pro, which is something that students can go into study for those. I'm not on the board for the CDR exam, but it's, you know, someplace, and I'm not any kind of remuneration, et cetera. I happen to write and approve questions in these very areas of management, human resources, et cetera. So I know specifically that we at least offer up as potential for studying for this exam, the CDR exam, we would have questions on it. So that's as best as I can answer.
Thank you. Okay, are there any other, knowing your content of the ENS exam, these questions in front of us, whether it's less than or not, is there anything else that you would like to draw to our attention that perhaps it's kind of not worded the same way that we would word it in the TDR exam, but you would like to elucidate that that particular area covered or not covered, so we can have more information about the CNS exam and how it relates to TDR exam?
Sure, yes, thank you. So I just want to make sure that we, you know, to point out the biggest difference, I think, is that we call things out specifically slightly different. Again, pointing out that it is very much a clinical exam. So biochemistry and medical nutrition therapy make up the majority of our exam. So we are not testing on things that are not outside of that clinical realm. We do educate those. There are, as Dr. Queen pointed out, that is part of the education that a CNS gets, but it is not something that we feel like we need to test on. We want the test to be very clinical to show that they have met the competencies needed to practice medical nutrition therapy. So like I said, we don't test for things outside of that. Our exam is 200 questions. It is very thorough. It is NCCA accredited, which is something, you know, that the CDR exam also is, which shows that we have the psychometrics, you know, for the exam, that it has validity, it has been tested. So I just want to point out that it is, in our opinion, it is equal to or higher than the CDR exam, just because it is clinically based only and doesn't bring in any other components of the practice.
Thank you, and we appreciate you stepping in when called to address the board.
Absolutely, you're welcome.
One quick thing to add, this is Derek for the record. I did reach out to the CDR to get additional information, but I was told what's available on the web is what I'm gonna get. However, approaching it differently, if we maybe want to have a representative from CDR come and speak, then that could.
Thank you so much for doing that. So my question is, as we progress this conversation, is as we see the difference between CNS, this is Proctor, between CNS and CDR exams, and the big glaring difference is the service management, human resource management, and some of the matters related to administrative roles that a provider may be engaged in that is outside of clinical patient care. So that's what I'm seeing. Just a second, Dr. Green. actually, go ahead, Dr.
Yes, thank you so much for pointing out those differences. I just would like to note, though, it doesn't mean that the exam is less than, but students are getting them in their education, nutrition business class, etc., even though they're not being particularly tested on it. And then one last note, I think that on the passing score, the Minimum Scaled Score for the CDR is 25 on a scale of 50. So that's a 50%, whereas the passing score for the CNS is 100 to 1000. Minimum score of 600 is required to pass, which is 60%. So there is a higher level of pass rate that's required for the CNS. So I just wanted to point that out. And that's all I have to have, is the only statement.
A while back, I looked at both of the credentialing of the RD and the CNS, and was quite evident that the CNS is more rigorous.
Thank you, Cable. A question to our policy analyst. Based our statutes are written and our law is, and our rules are written, provision whether or not the human resources and food service management testing this component, because we are not right now assessing education. Education is not right now under scrutiny. We're only scrutinizing the exam. That's it. So are there any provisions that would preclude us from using examination that does not contain these components of examination, regardless of the education, of the food service management and human resource, et cetera, and related factors management? Can we, for the this compliance to our law, can be, if exam is found to be not less than, does the board have a permission from the statutes to make a determination on less than with those two areas omitted or not? I would like to understand kind of where we are at so we can have kind of more clear discussions. Heather? Thank you.
Thank you. Again, this is Heather Vogelsong. So I'm going to ask a question to make sure I understand. So your question is whether the board can look at the CNS exam and determine whether it's not less than for, well, actually, let me go about this a different way. So for purposes of the Illinois applicant, there's a different consideration than for purposes of putting something in rule, okay? So if the board wanted to adopt a different exam in addition to the CDR exam or in lieu of the CDR exam or whatever it wanted to adopt and rule as the exam, it has the authority under statute to adopt an exam. The board just has to approve whatever exam it feels is required for applicants for pathway 1, which is going through the different steps, the exam, having the 900 hours. So if you wanted to adopt an additional exam, in addition to what you already have in your rules, you could do that. You have the authority to adopt an exam.
Thank you, Heather. May I please just back on what you said? I'm trying to understand slightly different nuance here. Can the board consider exam adoption for the exam that does not contain food service provisions, that does not test on food service and does not test on human resources? Does our law have anything about those components of practice that would require us to adopt only the exam that contains those provisions? Or are we free to determine that all the exams that are meeting those provisions are appropriate to our licensees?
Okay, great questions. And so again, two different things that we're looking at. in terms of adopting and rule your exam, there's nothing in the statute that says you need to have those particular things within an exam that you adopt. What the statute says is an exam prescribed by the office. So the statute does not say what the domains are or what the subject matter of that exam has to contain. So you have, as a board, the ability to adopt an exam and rule that you feel is the exam that should be required of applicants for going down a certain pathway. Okay, now, again, so that's on the rule side if you wanted to do that, which separate from this Illinois applicant, because the Illinois applicant came in under reciprocity, what the standard is for reciprocity of an applicant, which is under a different pathway, is that the laws of Illinois are not less than those required in Oregon. And so that's why the not less than language is in relation to this Illinois applicant. So what your discussion is whether the Illinois applicant, I'm sorry, whether the Illinois requirements, either individually or on a whole, are not less than what Oregon requires. So if you're going to look at the exam to exam requirement from Oregon's exam to Illinois exam, you'd be asking yourselves whether the exams that are allowed under Illinois are not less than what Oregon required at the time of this application, which was the CDR exam.
Thank you, Heather. We already voted on Illinois and accepted Illinois with our vote. So that vote has already took place. Now we are comparing CNS to CDR and determining whether or not. And I'm actually questioning, Dr. Pina, I saw your question just a minute. And I'm questioning whether or not we are asking the accurate question. Do we want to ask question if CNS is less than a CDR? Or do we want to ask a different question? Is CNS an acceptable exam for our state for dietitian? Is that the question? So Dr. Pina, the question?
I could also, thank you, this is Dr. Queen, maybe make a statement that is the CDR less than the CNS exam? So it could go both ways. So I think we need to also consider that there might be some missing components to the CDR that the CNS don't cover. So we have to consider also that side or that flip of the coin. And even though we're really trying to compare that there is some missing components to the CNS that the CDR does offer, and that could also relate also to the CDR to the CNS. So I think, as Heather pointed out, that it's important to see that we can accept through rules, and or if the SB 174 passes, that we can accept or decide to accept both exams. And that would be then appropriate to adopt both those exams.
Yeah, I do.
No.
Oh, if
Ann,
it's,
please.
thank you. This is Ann. If it's helpful, one of the things that we do when we get kind of lost in the ether is our grounding comes from vocabulary and our terms. And in your statutes, dietetics practice, which is what we were all here for, means the integration and application of principles derived from the sciences of nutrition, biochemistry, food, management, physiology, and behavioral and social sciences to achieve and maintain the health of people. So I'm already seeing some words here that are not in, maybe in some of the other areas. And again, it talks about appropriate standards and nutrition services, assessment of food and other sources of nutrition, meal preparation, things like that. So when we talk about equal or not equal, I always kind of come back to the heart of what dietetics practice find in your statutes, if that is useful.
You answered the question. Yeah, that was very helpful.
And answered mine.
Thank you.
Or for.
Well, yeah, you did it.
Fantastic.
Thank you.
This is Dr. Queen again. I think because in domain 6, medical nutrition therapy, it is wrapped up in meal planning, and food service is in that piece for the CNSs, even though it doesn't specifically state it. And again, that language is not specifically identified in that piece, but definitely in domain 6, that is something that is included in the medical nutrition therapy domain for the CNS. So I don't know if that helps or not either, but just to clarify that.
Okay, thank you. Dr. Queen, this is Ann. So the biggest thing, and again, I don't know, you have to help me. The CNS does not cover food systems management, correct? I thought I heard that. Or Amy?
In the test, it does not, but in education and curriculum, it does. But it is wrapped up also in domain 6 for the CNS under medical nutrition therapy.
Okay, well, we were just, we lost the screen. Josh, are we okay?
Yeah, we're fine.
Okay. Yeah, I thought we were just comparing, just for my own clarification, we were just comparing what folks who sit down for the exam are gonna have to know. And it's my understanding that anything outside of medical nutrition therapy would not be on the CNS, but the CDR does cover things like human resources and food system management. Am I understanding that correctly?
This is what I understand as well. So I guess I am back to a question. So that's why I asked it, like, according to our statutes, are the optional, and Heather said me, Amy, do you want to say something? Yes.
I'm sorry, I was just going to remind you that we said that those things are covered in domain, domain 8, which is the practice management. Again, we're going to that term management. It's in that last domain there.
Is the management that this is Ann, Amy, is the management that you were referring to, what does that look like in comparison to like food systems management? Because there's additional words on the CDR that I'm trying to understand.
I'm not familiar with what food service, I'm not sure what that means. What is the definition of that term?
Food systems management, you're talking about like hospital?
If I may, there's many. There's hospital food service management, there's restaurant management, there's management of food service in schools, in universities, in businesses, etc. So it's managed the production and distribution of food to all those populations and the regulations around those, which is different than management of medical nutrition therapy that both the nutritionists and the dietitians would do, in my mind, in planning meals for a specific patient or patient population around a condition.
Thank you. So, does the board have any thoughts about progression to what we want to do with this issue? We have, according to Heather, correct me, Heather, if I'm misunderstanding you, but we are free to say CNS exam is appropriate to our potential licensees, and we can accept it, even though it omits something that our statutes say our licensees will do during their practice. We get to do this. Or because our statute did clearly say that we need to have this food service management practice as part of our LD practice. And this exam does not identify those knowledge areas. Are we not free to vote to consider adoption of such exam?
Sorry, let me clarify.
Yes,
This is Ann. Heather, I'm sorry, I'll let you jump in there. It talks about nutrition, biochemistry, food, management, physiology and behavioral and social sciences to achieve and maintain the health.
thank you.
So there's a very important comment.
Yes, very important comma. So what I'm hearing then, this and
But just
based on
management
those
by itself,
provisions
right.
of the statute, this exam,
Which is
appears to meet those criteria. Heather, do you have any comment?
Yes, thank you. So, I think the issue statement regarding the exams was specifically in relation to helping the board understand, what was the requirements in Oregon versus the requirements in Illinois for the purpose of the Illinois applicant. And so again, I just am tying that back together, that the reason that this came to the board today was in relation to the Illinois applicant and being able to understand how the exams were in Illinois versus Oregon. So, but if the board is interested in changing a rule, to say that it would like to adopt a different exam or an additional exam, then yes, it has the authority to do that. But I think that what you would want to do is give direction to HLO to say that's something we're interested in doing, and let's do that at the next meeting so that it's properly noticed as going into a rule issue. And then you can work on that, give direction to HLO so that they can start working on rulemaking in that regard. So, but it wouldn't be at this meeting that you are adopting in rule another exam. Does that make sense?
Oh, of course, yes, thank you. So
Okay.
I see us as one potentially voting on whether or not based on the definitions that Ann just listed, does this exam is or not less than CDI exam based on the definition of the practice of dietetics? We still voting on that, right?
Well,
Yeah.
I think we're still discussing.
So I believe we should have taken up this issue before we did the thing with Illinois, because I did not think this had anything to do with Illinois. I mean, I guess I'm really confused, because now that we've specifically looked at these exams, then going back to Illinois, going on, is it less than? It might have a different outcome.
That's correct.
And so I know you can't squash a motion or a vote, but I'm not. This changes the landscape of the discussion of these issues in my mind. Because I frankly didn't know that was part of the Illinois discussion.
This is broader, same thing. I thought these are two different issues, but for me, my vote would stand for Illinois. Regardless, I think you maybe your vote would have changed, I don't know. However, right now, let's resolve what we want to do with this issue at hand.
I make a motion that we table issue 2 with more information coming from our wonderful staff for the next board meeting.
I would, this is Brockdorf, I would.
Is table the right word?
Yeah.
Okay.
I would, I think it may be, a lot of time has went into, one sec, Kimberly, discussion of this matter, and I think it may be worth it for us to have some sort of clarity. And for the purpose of that clarity, I would like us to vote on whether or not, based on what Ann read in the practice, that this exam versus CDI exam meets those provisions to practice the things outlined in our statute. So it's not less than, or it is less than. So I would like us to vote on that. Kimberly?
I would like to propose that we do vote to move this forward to adopt the CNS and then decide on the next meeting to make it a rule, include it in the rules, to make it a change to the rules.
Thank you, Dr. Queen. Today, based on the comments from our general counsel, we will not be doing adoptions. That will be discussed later in the next meeting. But we can still vote on the less than thing because we looked at this, we heard from experts. And I propose we still do hold the vote and have discussion on adoption at the next meeting.
Then I pull off my tabling motion since it wasn't seconded.
Okay, okay. Any more discussion on this question before I call, before we consider voting on this?
Okay, so if I may.
Yes,
This is Ann. I'm just trying to keep up. So it's my understanding that Jesse wanted to table the second issue. And that would be the exam issue, correct?
If it's gonna affect our particular board and the outcome of this board, not Illinois.
Okay, okay. And then Kimberly wanted to vote to accept the CNS. But we would need to notice that.
Yeah.
Because that's a big issue and we
Right.
can't do something that big without, I hope you understand, Dr. Queen. We can't do something that big without noticing the public.
That's right.
Understood. Yes, thank you.
No, thank you. And so we would need to put that on a later meeting. And so based on that, Ms. Jessie wanted to pull her original motion about tabling the second issue. Am I keeping up? Or did
Well,
I?
you are, but now you've said, may I? You've said something about, I don't know that tabling is correct. I appreciate that it has to be public notice.
Correct.
That
yes.
this issue is going to be brought up because I think you will, that's important and I.
And that's the exam issue, is that
Right,
what we're speaking
exam, yeah.
of? Okay.
And with that, I don't think it's would be appropriate for the board to vote without public input first.
On that issue.
On
that
the
issue.
exam.
On the exam issue, right,
Okay.
On adopting the exam issue.
or even comparing them and these, I mean, if, and correct me if I'm wrong, if you say they're equal and that goes out in the public comment, without their public.
Are you talking about the state of Illinois
No.
requirements?
No, I'm talking about the two exams.
Oh, the two exams.
This was posted and today we discussed it and it was in front of us to discuss it, comparing this. Next time the media will vote, if you choose to, on whether or not we're going to adopt or not adopt, but I do think we still need to vote on whether or not on the less than topic. So anybody would like to make a motion?
So just for clarity, where we are is that Yulia would like us to continue. You would like us to weigh the not less than Illinois requirements for the purposes of this app.
No, I would like the applicant we already voted for.
Yeah.
That's
okay.
That's a closed issue.
Oh, okay, all right.
Yeah.
And so now we're just talking about.
Just thinking that this is because we did not understand, and forgive me, I should have asked additional questions. I did not understand one connected to the other. This is broader. So now we've been dissecting these exams, we have heard, and I would like to ask to vote. Now, next time the board meets, board can choose to adopt or not adopt the exam. That's the board's decision. Next time we have public comment and we can hear and we can have a discussion. I just said, Jesse, and, but today I would like us to vote on our understanding on the less than issue. I would like to know what the board stands, and I would like to have the understanding and vote on that.
I'm gonna defer to Bob, I think, because he may have a more appropriate comment.
This is Bob. I'm just kind of confused on what we're actually voting on, because if the board chooses to adopt or agrees that the CNS can be accepted, we still have to go through the rule writing process, which includes public interest parties. And then we would bring the rule back to the board to vote on.
Yes. Exactly.
So I'm not sure what we're voting on.
We are voting, the way I'm understanding is like original sentence that Derek made, and whether or not the CNS exam is less than with a clarification based on the outline practice as Anne read to us. So that would be a vote.
So I understand we're gonna vote that it's not less than,
Yes.
and then we'll work.
What we do with that is up to us. We can just vote and let it sit, or we vote, we do something, we don't do something with it.
You have to do something if you vote.
But then we can do it next time. You cannot do everything today without public,
Right.
opportunity
yeah,
for public
the
comment,
rules
yeah.
Process.
Yeah, to accept the, this is Ann, to formally accept either the CDR or the CNS if the board chooses to do that and it's been vetted and it's something that we can do. We would have to go through the rulemaking process. Wherever we're doing a rule, it's very, very important to include the public or anybody who might be involved in that. And so that would be something where we would have a proposed rule. That would be something that I think Iraq would want to weigh in on a rules advisory committee, bringing all the stakeholders in. And then obviously the board would propose, they'd review any public comment, and it would have to be voted in permanent to accept that exam in full. So that's a whole separate
Yeah.
process for that.
We're not doing that today at all. We are just voting on whether or not, based on the practice of the dietetics listed in our statutes, one exam is not less than the other exam.
So a vote of the board is not binding? I guess I don't understand. I don't understand how you have
Yeah,
a vote.
Bob, I
and
think,
not bind us to, therefore, even to change the rules.
I think what Chair is trying to get us to is to give us direction, maybe not necessarily need a vote, but give us direction to open rules to bring the nutritionist exam into the fold.
Yes, because if we do not vote on this, there is no real reason for us to do all the rigmarole and open up the rules and move forward.
So you can give us direction.
You can give us a chance. So
Yeah.
I would like for us to, if somebody wants to make a motion,
Okay. I'll make a motion that we adopt the CNS, the CNS is equal to the RD,
Not less than.
and not less than.
let me just understand that what I'm hearing from Kegel is that you're making a motion to vote on whether or not CNS examination is not less than CVR examination for the purposes of licensure as dietitian in state of Oregon. Is that right?
Correct.
Does anyone have a second?
And you're giving us direction to,
I will, this is Queen. I will second the motion.
Okay, and given, yes, and add in the direction to start the process of looking into the. You might want to work that as an idea.
We've got a first and a second, so if we're doing. this
Okay, you're gonna,
Okay.
you're gonna do the roll. Okay. Raptor, aye, Pavlinen,
Nay.
Kegel,
Yes,
Awful,
Nay.
Queen,
Yes.
what do we have? Math,
3-2.
3-2.
Yeah. Passes.
so,
And
so
you
this,
voted for yourself?
so this does not, the CNS does not immediately go into
No,
executive.
no,
Except-
no,
Okay, I just wanted to get that out there. that you- Heather?
Heather?
I'm not.
So based on the vote of a 3-2, that's not enough to pass, given what you guys have as a requirement for passing. You would need at least 4 votes to have passed that. So for today's vote, the vote does not pass, but that does not mean that you cannot discuss it at a future meeting or gather more information or whatnot. But it's just that that vote did not pass.
Question and then follow-up question. So part of the vote was to give direction to the health licensing office to start the proceedings. Do we want to open up and just vote on that direction only? Asking you to, or can you just ask you to do that?
Won't pass anyway, because we don't.
So first,
Different, different. Just on asking them to look into it.
Public comment. Just a question, do we always need 4 for everything we vote on?
Get somebody else.
Then if we need 4 on everything, yes, okay.
Yeah.
Okay, thank you.
Yeah, thank you. So I would like to understand, someone please help me out. Do we want to, this motion failed? Do we want to have a motion of asking the health licensing office to give you direction to put the public comment out so we can discuss it next time?
We have to,
We don't need to have a motion.
no, well, yeah, you don't have to have a motion to ask us to do something or give us direction. This is Bob, by the way. But because the motion didn't pass, I think what we do is bring it back when we have more members present to either get to the 4 one way or the other.
Right. That was what I was going to say, just in a not as nice way as you, not in the correct legal way of saying it. Because if we didn't have enough to vote, why would we have authorized staff to do all this work when we don't know what the vote would be later?
So it's my.
That's a lot of work for them.
Yeah, so my understanding is there's a consensus that it may not be less than, and then there's some consensus that it may be less than. So when we get the entire board together, if it comes to fruition that it is not less than, then we'll.
Right.
Okay, now I'm confused.
So again, it comes back to the tabling, the next time you would like to see it on our agenda.
If it's on the agenda and the board says, there's an agreement that, we should move forward with rule writing to look at adopting it, then we would do it at that point. But if the board says, no, it's not, then, we're done and we'll wait for
So
1174.
just so I understand, so the next meeting. Number one, we will know what is gonna happen with 1174 by then. Because if this creates a separate licensure path, and it pretty much explodes your whole world, and it's gonna come down and look differently. That then we will know what we have to do. If there's a separate licensure path for nutritionists, then it doesn't matter which is which, so just to offer that as a point of clarification, if we want to looks now that the CNS, the motion that the CNS app exam is not less than the RD exam, that didn't pass. Okay, so right now we don't really have any direction. If I understand you correctly, I've been trying to keep up. If you like, in October, when you meet next, we will know. If this bill doesn't pass, we will need to address some issues with our existing world. If the world changes, some of the decisions we made here today would matter, right? So if you like, we could wait and see what the river of legislation leaves us with in October, and then we can proceed appropriate. Does that make sense?
Yeah, that's logical.
So can we table it?
That's the next one.
Well, yeah, I mean, what we could do is, I could do the scarecrow and the Wizard of Oz and give you both ways, but if you like, the direction you could give me, and I'm happy to log it, is if the legislation doesn't pass, you at the next board meeting, if I understood you all correctly, want a deeper dive on the 2 exam comparisons, if we wanted to have somebody from CDR here, or if we wanted to actually talk about maybe accepting the CNS in rule. I mean, tell me if the legislation passes, this is all kind of moot, right? If it doesn't, what would you like me to bring forth in October for you?
I would love this is prerogative. I would love us to look at it and really come to some sort of very clear decision.
On the exam piece?
On the exam, what's acceptable for us, to be adopting, to be not, and Yeah, because then we need to address the issue. It's not gonna go away.
Right.
It's that it's only going to keep expanding, so.
Yeah, Jim.
So from a legal perspective, I'm gonna ask her to come back. Since I know we can do rules, but can we do rules that are against the statute?
No.
Which talks about management. It is management, which is human resource, no,
Service?
no, management, which is human resources, accreditation, all that, which it's not always, it's management. It can be management of practice, but it can also be management of it. Yeah, so we can't make a rule that is contrary to our statute.
The statute.
She's back.
Yeah, she's back.
She's back.
Hi, this is Heather again. So first I'm going to direct you to what the statute says. 691435 says passes an examination prescribed by the office. So it does not say what that examination needs to contain. Okay. And then in answer to your question, no, you cannot make a rule that conflicts with statute. So, but you can have a discussion as to whether there is an exam that you want to adopt in rule that you feel would be appropriate for licensure under Pathway 1. And what the statute says is it's an examination prescribed by the office. And then it would be up for discussion as to what exam meets the board feels is necessary for licensees doing Pathway 1.
Thank you.
Okay.
And yeah, the statute is over 30 years old.
So at the next meeting, if the statute passes or the bill passes, we got a lot of work to do. You know, we're gonna have to rebuild the work. If it doesn't, what would you like me to provide for you? And you can think about this and we can get through public comment if you want, and we can do that under other board business. If you would like to gather your thoughts, if that's more appropriate, because I don't want anyone, we've thrown a lot of stuff at you today and it's hard to keep it all straight. I can speak for myself how hard that is. So what would you got? Oh, Dr. Queen.
Yes, this is Dr. Queen. Thank you. Can we just add it to the agenda? And then if last minute, we can just take it off the agenda to, that way it's there. It reminds us to either vote on it again or to bring it up as a rule change, depending on where we're going to go, because we're going to have new members also.
Okay.
They're going to be part of the board. So that's a suggestion.
Let me clarify. So Dr. Queen, at the next meeting, you would like an agenda item that addresses the possible adoption, I'm trying to get the word, of the CNS as an exam for licensure. Am I capturing that correctly?
Correct, yes.
Can we move on to public comment? Anything else that I'm missing? Yep. Okay, at this time, the Board of Licensing will hear public and interested party feedback. Public comment is limited to matters listed on the meeting agenda or topics relevant to the board has statutory authority to regulate. Comments will be limited to 3 minutes and will not be allowed if they are disruptive to the board's conduct of its business. If you are called to comment, HLO staff will request the public member to unmute himself. Chairperson and HLO reserves the right to end person's comment early and have HLO staff mute the public member if the comment does not pertain to matter listed on the meeting agenda or topic relevant to what this board has statutory authority to regulate. Are there any members of the public who wish to comment? If so, please raise your hand and use the Teams right hand feature and they can be acknowledged.
Any job to be on your end?
I got no communication with, anybody wanting.
So any other, we can address other board business, right?
We're through public comment. We certainly can.
Which is, we've already addressed it. Correct.
So any other board business?
Anything else?
The board business, for the board? Actually,
Well, I just wanted to say next time Ms. Jessie will be the chair. Danica.
Hard act to follow, ma'am.
That's part of the other board business. Yes, it's end of an era. But please come back and see us. Other than the, the band we've got going here. So I have some direction on the next agenda. If there's anything else that pops to mind, just to let you know before you start discussing this, if you would like Derek to provide something, myself, just reach out and we will take care of it for you to the best of our ability. So other than that item, is there anything else anyone would like to discuss? Some new meeting, members next time.
The edition meeting is adjourned at 11:16 a.m. on Wednesday, April 16th, 2025. Thank you, everybody.
Thank you, everybody.
Bye.